in regard to an overseas mission undertaken by Mr. Dick Ning Xinghua, Chairperson of the Information and Communication Technologies Authority. Moreover, Honorable Juman has, on the basis of copy of a purchase order issued by the ICTA, which he annexed to the said letter, he stated that the Honorable Deputy Prime Minister has, I quote, misled the House. I am of the view that in so doing, the Honorable Member formed the opinion that the purchase order de facto challenges the reply given to the House by the Honorable Deputy Prime Minister, which was to the effect that, inasmuch as the trip effected by the chairperson of the ICTA, to which the parliamentary question referred, was a private trip, neither government nor the ICTA was responsible for any attended costs. Honourable members, on a procedural note, I wish to draw the attention of the House to the following. Firstly, Honourable Juman addressed to me a letter containing serious allegations against the Honourable Deputy Prime Minister in no equivocal terms, which is tantamount to challenging the conduct of the latter, and requested me to call him to order. Standing Order 45 lays down the procedure available to a honourable member wishing to challenge the conduct of another honourable member before the House, and which reads as follows, I quote, "The conduct of the President and Vice President of the Republic, or the person performing the functions of the President's office, the Speaker, members of the Assembly, judges, members of statutory commissions, or other persons engaged in the administration of justice shall not be raised except upon a substantive motion moved for that purpose and in any amendment, question to a minister or remarks in a debate dealing with any of the subject, reference to the conduct of the persons aforesaid shall be out of order." In the light of the aforesaid, the course of action initiated by Honourable Juman is, to all intents and purposes, procedurally incorrect. Moreover, I wish to apprise the House that by letter dated 29th April 2022, the attention of Honourable Juman was drawn to the fact that the procedure that obtains in relation to the subject matter and tenor of his letter, dated 27th April 2022, is contained in Standing Order 45. Honourable members, on another note, however, I have to inform the House that I view with much concern the fact that the letter which Honourable Juman addressed to me found its way in the edition of L'Express dated 28th April 2022, inasmuch as same is deemed to be of private nature and to which I have not yet replied. Honourable members, while on one hand Honourable Juman acted in complete oblivion of the provisions of Standing Order 45, he has, on the other hand, defied elementary and basic principles of parliamentary etiquette and traditions by causing to be published a letter containing serious allegations against another honourable member, thus bringing Parliament, the temple of democracy, which epitomizes the will of the people, into disrepute. Honourable members, it has regrettably been observed that some honourable members have taken the habit of bringing procedural issues in the public domain. through the media, while same can best be dealt with in Parliament. Oblivious of the grave consequences that same can have in the mind of the public and on the institution, and what same can entail for themselves. I can only appeal to honourable members to stand guided by such a conduct as to glorify the decorum and dignity of this august assembly, which we have all humbly pledged to uphold at all its stages, at all times. I thank you for your attention.
Papers have been laid. Questions?
B 5 to 4.
Mr. Speaker, sir, in my reply to parliamentary question B387 at the sitting of 18th of May 2021, I explained the various implications and challenges for the introduction of live broadcast of news bulletin in the Mauritian Sign Language. I also informed that the Mauritius Broadcasting Corporation was working in close collaboration with the Ministry of Social Integration, Social Security and National Solidarity, and the Society for the Welfare of the Deaf to examine those implications and challenges, and that they were considering the advisability of implementing the project in a phased manner. That is, in the first instance, increasing the number of weekly news bulletins in the Mauritian Sign Language from 1 to 2, and at a later stage, identifying a specific live news bulletin to include the sign language interpretation. Mr. Speaker, sir, the House will recall that the news bulletin in the Mauritian Sign Language was first introduced in 2007 and was broadcast on Saturdays on MBC2 only. The duration of the broadcast in those days was around 5 minutes. As from November 2015, the bulletin was broadcast on 3 channels, namely MBC One, Seine Creole, and MBC Sat. In December 2020, the duration of the news bulletin was increased from 5 to around 12 minutes. This news bulletin in the Mauritian Sign Language is currently being broadcast every Saturday on MBC One, MBC Sat, and Seine Creole at 17:48 hours, 17:15 hours, and 19:18 hours, respectively. This news bulletin is also rebroadcast on MBC One on the next day at 12:25 hours. Mr. Speaker, sir, I am informed that a meeting was convened by the Mauritius Broadcasting Corporation on 10th of August 2020 with representatives of the Ministry of Social Integration, Social Security and National Solidarity, and the Society for the Welfare of the Deaf, to examine ways and means of introducing live news bulletin in the Mauritian Sign Language. The Society for the Welfare of the Deaf had pointed out that competent staff had to be sent to India for training as interpreters and newscasters for the hearing impaired. Further, discussions in this line were put on hold in view of the COVID-19 pandemic and travel restrictions. A second meeting was held at the Mauritius Broadcasting Corporation on 26th of May 2021 with, inter alia, the representatives of the Ministry of Social Integration, Social Security and National Solidarity, and the Society for the Welfare of the Deaf for follow-up actions. During the meeting, the representative of the Society for the Welfare of the Deaf reiterated that in order to produce a daily live news bulletin, additional human resources would have to be trained as interpreters and newscasters. The cost implications for all stakeholders were also discussed. In view of the lack of adequately trained personnel at this stage, the Society for the Welfare of the Deaf made a request for a midweek Mauritian Sign Language news bulletin, in addition to the one being broadcast on Saturdays. It was agreed that the technical facilities would be provided by the MBC, while the mode of financing the fees for the Mauritian Sign Language interpreters and newscasters would have to be examined. Mr. Speaker, sir, a follow-up meeting was held at the Mauritius Broadcasting Corporation on 28th of January 2022 with all stakeholders, including the chairperson of Society for the Welfare of the Deaf, to discuss the matter further and chart a way forward. The representative of the Society for the Welfare of the Deaf confirmed that live telecast of the news bulletin cannot be entertained for the time being due to lack of interpreters and newscasters. The Society has indicated that for daily live news bulletin in Mauritian Sign Language to become a reality, a pool of interpreters will first have to be trained in the Mauritian Sign Language. The Society has further indicated that such training would take around 2 years. Presently, there are 3 hearing interpreters and 8 deaf newscasters, and they would not be sufficient for the proposed live telecast of news bulletin in the Mauritian Sign Language. Mr. Speaker, sir, I am informed that for 2 news bulletins in the Mauritian Sign Language, the services of 3 interpreters and 8 deaf newscasters would be required. The deaf newscasters would work in 2 batches of 4 persons, one for the Saturday news bulletin and the second one for the proposed midweek news bulletin. I am further informed that the training program for the Mauritian Sign Language interpreters comprises 2 phases. The Ministry of Social Integration, Social Security and National Solidarity has taken the initiative of mounting locally the first phase of the training program, which will be conducted by the Mauritius Institute of Training and Development in collaboration with the Society for the Welfare of the Deaf. Phase 1 will be geared towards imparting participants with the basic communication skills in Mauritian Sign Language and will be conducted in 4 different batches of 3 months duration each. Successful participants from the different batches in the first phase will be retained for further training in the second phase, which aims to develop communicative proficiency in Mauritian Sign Language. The second phase consists of 6 modules, which is covered over a period of 1 year. At the end of the course, there will be a 2 weeks visit abroad for exposure and assessment. This second phase of the training program will be conducted in collaboration with the Indian Sign Language Interpreters Association, which is affiliated with the World Association of Sign Language of Interpreters. Mr. Speaker, sir, it has been agreed by all parties that the proposed mid-week news bulletin in the Mauritian Sign Language be considered for the time being, and for which the MBC is ready to provide all technical facilities and backup for the early kickstart of the project. Thank you.
Thank you. The Honourable Prime Minister just said that interpreters still need to be trained in Mauritian Sign Language. But in 2020, following my PQB 521 on the same subject, which is live broadcast in Mauritian Sign Language, the Prime Minister said that in the past, we asked for assistance from South Africa. Can he indicate to the House what kind of assistance was asked? And most importantly, what was the outcome? Because the years go by and live broadcast in Mauritian Sign Language is still not a reality.
Well, Mr. Speaker, sir, I am informed that the Mauritian Sign Language is not being taught and lectured in many other countries. And the most appropriate one, this is what I've been informed by the Society for the Welfare of the Deaf, is that it is India, in India. And they have a collaboration with India. And in the past, I believe that some trainers have been, some interpreters have been trained in India. So whether South Africa is also another country where we can send people, up to now, I am not aware. But I have replied, the issue of training, of course, has been looked at very carefully. And it is unfortunate that during the time where we wanted to move forward, unfortunately, the borders were closed. And then we had, of course, restrictions because of the COVID situation. And then India itself, you will recall that even after we had relaxed in terms of our borders, India still had very strict border control. So it is only now that, as I have stated in my answer, that we are looking at how we can have at least some people to be trained in India.
L'honorable Premier ministre parle de frontières fermées, mais dans ses réponses précédentes à mes questions parlementaires sur le même sujet, c'est-à-dire sur la retransmission en direct des bulletins télévisés en langage des signes, tout comme la réponse qu'il vient de donner à l'instant, l'honorable Premier ministre met en avant le manque de facilités techniques pour permettre aux sourds et malentendants de suivre les bulletins télévisés en direct, et surtout il met en avant le coût onéreux. Mais le Premier ministre n'est-il pas d'accord qu'il faudrait revoir les priorités? Car il s'agit ici d'inclusivité, il s'agit du respect des droits humains, il s'agit du respect de la Convention des Nations Unies sur les droits des personnes en situation de handicap, dont Maurice est signataire. Et si son gouvernement peut dépenser des milliards dans des projets d'infrastructure, j'arrive avec ma question, et des millions dans des podiums, cela devrait être possible. Est-ce que l'honorable Premier ministre n'est-il pas d'accord que cela devrait être possible d'investir ce qui est nécessaire pour que la communauté des sourds et malentendants ne soit pas discriminée?
Monsieur le Président, je pense qu'il faut faire rappeler à l'honorable membre que son parti a été au gouvernement de 2000 à 2005. Et à ce moment, il n'y avait pas le droit des personnes handicapées, des personnes sourdes. Il y avait 5 ans. 5 ans pour demander à la MBC de faire ce qu'on est en train de demander aujourd'hui. Mais seulement, il faut quand même admettre que, comme j'ai dit dans ma réponse, le fait qu'on ait commencé avec un news bulletin de 5 minutes, de 4 à 5 minutes, et au fil des années, ça a augmenté. Je suis d'accord que ce n'est pas suffisant. Je suis d'accord qu'il faut faire encore plus. Et c'est la raison pour laquelle le côté technique a été revu. Je sais que évidemment, ce que j'ai répondu auparavant, c'est la réalité. Il y a toute une organisation à mettre en place au niveau de la MBC. Mais après discussion avec la société, avec le ministère Social Security, on est tombé d'accord que allons bouger par phase. Allons bouger par phase et allons essayer d'augmenter le news bulletin qui se fait actuellement une fois la semaine et qui est répété le lendemain. C'est-à-dire le même news bulletin qui est recorded mais qui est rediffusé. Allons essayer de voir comment on peut augmenter à 2 fois par semaine. Et ce que je comprends, que la MBC a travaillé dans ce sens, et la MBC, très probablement, dans un proche avenir, va être prêt donc, pour pouvoir diffuser ce deuxième bulletin. Mais seulement, il y a aussi les coûts. Donc, on est en train de voir le ministère de la Sécurité sociale, les autres ministères, on est en train de travailler pour voir comment on peut trouver le financement nécessaire pour faire ce deuxième bulletin devenir une réalité. Et puis, il y a à long terme, il faut, après avoir, si on arrive à réaliser ce deuxième bulletin, il faut essayer de voir comment on peut non seulement continuer à augmenter le nombre de bulletins, mais éventuellement pour venir avec le live broadcast in the Mauritian Sign Language.
The House will recall that India, since the Prime Minister was talking about India, enacted its accessibility standards for persons with disabilities in television programs. So can the Honourable Prime Minister indicate to the House whether Mauritius will enable the enactment of such standards in Mauritius?
Sorry, which standard is the Honourable Member talking about?
India enacted its accessibility standards for persons with disabilities in television programs. Since the Prime Minister was talking about India, can he indicate to the House whether we will ask for assistance with India for the enactment of such standards?
Well, Mr. Speaker, sir, each country has provided different regulations and different laws adapted to its situation. Of course, we want to improve in Mauritius with regard to accessibility of people who are autrement capables. And of course, whatever assistance we can get from not only India but from other countries, of course we will tap from those assistance.
The table is advised that PQB 537 will be replied by the Honourable Minister of Information Technology, Communication and Innovation. That PQB 587 and B614 will be replied by the Honourable Prime Minister, time permitting. That PQB 528, 536, 540, 587 have been withdrawn. Next question.
B525.
Mr. Speaker, sir, I will reply to parliamentary questions B525 and B530 together as they relate to the same subject matter. Mr. Speaker, sir, Mr. PU was never deported from Mauritius. The issue of issuing and executing a deportation order against him do not, therefore, in any way arise. There has also been no breach of an injunction issued by a judge of the Supreme Court, as I will explain later. Mr. Speaker, sir, at this juncture, let me hasten to say that it is preposterous to even imagine that the government and the institutions of this country would flout the rule of law at the risk of damaging their credibility over the removal of a foreign citizen whose name was, until a few days ago, unknown to the general public. It is high time that good sense prevails and that those who are creating sensationalism out of gross misinformation take responsibility for their actions. Mr. Speaker, sir, allow me to take this opportunity to set the record straight. Mr. Piu, a Slovak national born on 28 May 1970 in Slovakia, came to Mauritius on 19 February 2019 from Kenya. He was allowed to land for a period of 30 days on a tourist visa. On 14th of March 2019, he submitted an online application through the Economic Development Board for an occupation permit to stay and work in Mauritius as professional with Eurocola Mauritius Limited. He left the country on 2nd of April 2019 for Réunion Island. He returned on 3rd of April 2019 from Réunion Island and was allowed to land for a period of 50 days on a business visa. Mr. Speaker, sir, I am informed that on 5th April 2019, a search on the name PU was carried out on the controversial list of the Passport and Immigration Office, the Interpol database, and World Check, and the search returned no result. His application for an occupation permit was therefore approved for a period of 3 years. An appointment was scheduled on 19th April 2019 for Mr. Piu to call personally at the Passport and Immigration Office to submit original documents for the issuance of the occupation permit. I am further informed that on 19th April 2019, prior to the issuance of the occupation permit, a search on the name PU was again carried out on the controversial list of the Passport and Immigration Office, the Interpol database, and World Check, and the search revealed nothing adverse against him. On this basis, PU was issued with an occupation permit to stay and work in Mauritius as professional for the post of Product Director with Eurocola Mauritius Limited, valid until 18th of April 2022. Mr. Speaker, sir, I am also informed that on 5th November 2020, the Attorney General's Office received a request dated 6th August 2020 from the Slovak Republic for the arrest and extradition of PU. According to the Slovak authorities, he was wanted for prosecution in the Slovak Republic for, I quote, A, establishing, masterminding, and supporting a criminal group for which he was liable to a term of imprisonment of 5 to 10 years, and B, illicit manufacture, possession of trafficking in narcotics and psychotropic substances, poisons or precursors, for which he was liable to a term of imprisonment of 20 to 25 years or life imprisonment altogether, unquote. It is appropriate to note that at the time of the receipt of the request, our borders had been closed since the 19th March 2020 and were only fully reopened on 1st October 2021, this on account of the COVID-19 pandemic. On 25th January 2021, the Attorney General's Office wrote to the appropriate authorities in Mauritius to confirm the presence of PU in the country. Having confirmed that PU was in Mauritius, draft applications for extradition and arrest pending extradition were prepared by the Attorney General's Office by 22nd of March 2021. However, the applications were kept in abeyance due to the second lockdown that began on 10th of March 2021 and ended on 30th of April 2021. Upon the reopening of the Mauritian borders on 1st October 2021, I am informed that the Attorney General's Office again wrote to the appropriate authorities to confirm the presence of PU in Mauritius, and having received such confirmation on 28th October 2021, went on to ascertain whether the Slovakian authorities were ready, willing, and able to remove PU from Mauritius should an extradition order be made against him. On 15th of February 2022, the Attorney General's Office received confirmation that the Slovakian authorities were ready, willing, and able to remove PU from Mauritius. Applications for the extradition of PU and his arrest pending extradition were lodged on 22nd of February 2022 before the District Court of Port Louis. He was arrested on 22nd of February 2022 and granted bail on 9th March 2022. Extradition proceedings have been ongoing and the hearing has been fixed for 11th of May 2022. It is worth noting that in the meantime, the occupation permit of PU was to expire on Monday, 18th of April 2022. Mr. Speaker, sir, meanwhile, on 23rd March 2022, while extradition proceedings were still ongoing, the Registrar of Civil Status informed my office of the publication of the proposed civil marriage between PU and Miss MJDA, a citizen of Mauritius, had been received and was requesting a clearance certificate before the date of the wedding. On 28th of March 2022, the Secretary for Home Affairs informed the Registrar of Civil Status of an objection to the intended marriage on the ground that PU was trying to marry a Mauritian citizen for the sole purpose of acquiring the status of resident. On 31st of March 2022, PU submitted an application for the renewal of his occupation permit as professional with Eurocola Mauritius Limited through the Economic Development Board, which was due to expire on 18th of April 2022. Mr. Speaker, sir, at this juncture, it became essential to take a decision on the status of resident of PU, who, let me recall, was wanted in the Republic of Slovakia for establishing, masterminding, and supporting a criminal group and illicit manufacture, possession of trafficking in narcotics and psychotropic substances, poisons, or precursors. From information received from Slovak authorities, for the period 2015 to 2018, PU and his criminal group provided precursors in the form of pills for the production of approximately 480 kilograms of methamphetamine for a value of at least 16.8 million euros. That is about 758.5 million rupees. Without resorting to expert literature on the subject, a Google search of the word methamphetamine returns the following result: a synthetic drug with more rapid and lasting effects than amphetamine used illegally as a stimulant. Mr. Speaker, sir, everybody is aware of my personal engagement in the fight against this scourge of our society known as substance abuse, as well as the associated trading and trafficking in illegal drugs. The real treasure of this country is its human resource, and it is truly heartbreaking to see how substance abuse is ruining the lives of youth with great potential in this country. I wish that those who are taxing the government and institutions of this country of having committed an illegal act in connection with the removal of PU from Mauritius never experience the heartache of having a child hooked up on methamphetamine. Expert literature describes methamphetamine as a powerful and highly addictive substance. It is known to have caused death or serious brain damage in youngsters who had been initiated to the substance. With this in mind, Mr. Speaker, sir, my only option as the minister responsible for the subject of immigration was to deprive PU of his status of resident by invoking Section 6 and 9A, subparagraph 8 of the Immigration Act. Mr. Speaker, sir, as much as I am unflinchingly committed about cracking down on substance abuse and illegal drug trade and trafficking in this country, I am a fervent advocate of the rule of law. It baffles me that persons who have taken the sacred oath to be faithful and bear true allegiance to the Republic of Mauritius according to law, and to well and truly discharge the duties of a barrister according to law, would use misinformation to manipulate public opinion. The latest that I have heard is that these persons are brandishing a clean certificate of character issued by the Director of Public Prosecutions of Mauritius in respect of PU on 8th of March 2022. Mr. Speaker, sir, of course, Mr. PU will have a clean certificate of character in Mauritius, as he has never committed a criminal offense in our territory. But that does not automatically wipe out his antecedents as a wanted fugitive reported armed and dangerous by Interpol. I am not the judge of these persons, but I remain convinced that the legal profession remains at the core a noble profession, and that these people will be appropriately judged by their peers. Mr. Speaker, sir, in dealing with Mr. PU, my office and myself have ensured that we have scrupulously observed the laws of this land. I am well aware that this august assembly is not the forum to ventilate issues of law. There are courts that have been set up in this land for this purpose. but in view of the misinformation that is circulating around this matter, as is evidenced by the equally misinformed questions B525 and B530 being asked, I find myself obliged to expatiate on the legal provisions underpinning the removal of PU from this country. On 15th of April 2022, based on Section 6 and 9A8 of the Immigration Act, and in my absolute discretion and in the public interest, as the law allows me as Minister responsible for the subject of immigration, I deprived PU of his status of resident. I am informed that the notice of deprivation of the status of resident was served by registered post at the last known address of PU on 26th of April 2022, as required by Section 6(6) of the Immigration Act. And for good measure, I am quoting these sections. I quote, Section 6, loss of status of resident, subsection 1, where, in relation to a resident, the Minister is satisfied that it is in the public interest to do so, he may, in his absolute discretion, deprive him of his status of resident. And subsection 6 reads as follows. Where a resident is deprived of his status of resident, a notice to that effect shall be served upon him by post at his last known address. Section 9A, occupation permit, subsection A. Sections 6 and 6A shall apply to a person who has been issued with an occupation permit as they would have applied to a person who has acquired the status of resident, unquote. As can be noted, these provisions operate independently of any extradition or deportation proceedings. The moment a person is deprived of his status of resident, he has no legal standing to be on the Mauritian territory, as can be seen from sections 3 and 4 of the Immigration Act, which provides as follows. I quote, restriction on admission to Mauritius, subsection 3. Subject to this act, no person may be admitted to Mauritius or, being within Mauritius, remain there. Subsection 4, entitlement to admission to Mauritius. Subject to this act, a citizen, a permanent resident, or an exempted person shall be allowed to enter Mauritius or, being in Mauritius, to remain there so long as he holds his status of citizen, permanent resident, or exempted person, as the case may be, unquote. Mr. Speaker, sir, in the whole campaign of misinformation and disinformation surrounding this matter, I have heard it said that it was necessary to resort to deportation under the Deportation Act once a person is deprived of his status of resident and becomes a prohibited immigrant. Mr. Speaker, sir, I have here to refer this August Assembly to Section 6, subsection 5 of the Immigration Act, which provides as follows, I quote, where a person has been deprived of his status of resident under subsection 1 or has ceased to be a resident under subsections 2, 3, or 4, he shall be deemed to be a prohibited immigrant for the purposes of this Act and of the Deportation Act, unquote. It would seem that the learned people who are taxing the government and the institutions of this country of having acted illegally, inadvertently, or worse, knowingly, miss the fact that a person who is deprived of his status of resident becomes a prohibited immigrant for the purpose of the Immigration Act. At this juncture, I find it necessary to quote Section 20 of the Immigration Act, which provides that, and I quote, any person who is detained by virtue of this act shall, whilst being detained and whilst being conveyed for the purpose of being removed from Mauritius, be deemed to be in lawful custody, unquote. Upon being deprived of his status of resident under Section 6, 1, and 9A8 of the Immigration Act, Mr. Piyu was on 26 April 2022 lawfully conveyed by the police under Section 20 of the Act for his removal by the Slovakian authorities. It is to be noted that at no material time was the police the object of a court order. Mr. Speaker, sir, coming to deportation, which is altogether a completely different process in itself, it is appropriate to refer to Section 4 of the Deportation Act, which provides as follows, I quote, subject to this act, the minister may, if he thinks fit, make a deportation order in such form as may be prescribed in respect of A, a convicted person, B, an undesirable person, C, a destitute person, or D, a prohibited immigrant, unquote. Mr. Speaker, sir, on the clear express wording of the law, deportation is an option that is open to the minister. It is not mandatory that a person who has been declared a prohibited immigrant be deported if the authorities of the country of which he is a national are present in Mauritius and ready, willing, and able to take him back to his country. Here, it has to be stressed that the Republic of Slovakia is a member of the European Union and bound by the European Convention on Human Rights, from which Chapter 2 of our Constitution is inspired. The handing over of Piyu to and his removal by the Slovakian authorities was perfectly lawful, and the same fundamental human rights guaranteed under our Constitution will continue to apply to him. Mr. Speaker, sir, let me now address the erroneous information that is circulating to the effect that an order of our Supreme Court has been flouted. The order was an interim order in the nature of an injunction prohibiting and restraining the state of Mauritius, the Prime Minister, the Passport and Immigration Officer, the Attorney General, and the Director of Civil Aviation from, I quote, 1, deporting the applicant from Mauritius without complying with the provisions of the Deportation Act, and 2, extraditing the applicant and or removing him from Mauritius prior to the conclusion of the extradition hearing, cause number so-and-so, before the District Court of Port Louis, unquote. It is clear that Piyu was neither deported nor extradited from Mauritius, but was removed from Mauritius by the Slovakian authorities. The part played by the police was mere lawful conveyance under Section 20 of the Immigration Act that I have just cited. The Mauritian authorities, cited in the order, did not remove Mr. Piyu from Mauritius. This would have entailed positive actions, like, for example, securing a place on a flight and escorting him to Slovakia, which is not the case here. The question of flouting a court order, therefore, does not arise. Let me conclude, Mr. Speaker, sir, by saying that even though Section 6.1 of the Immigration Act gives me an absolute discretion, my decision to deprive PU of his status of resident is still reviewable by the courts on the authority of Green versus Prime Minister and Minister of Home Affairs, 1993 Supreme Court judgment at page 389. I will invite anybody who is aggrieved by my decision and who has sufficient legal standing to do so, to challenge the decision before a court of law as civilized people would do in a civilized state governed by the rule of law. Finally, I am informed of a communication from the Slovakian authorities as follows. And I quote, "For completeness, we would like to state that by the judgment of the Specialized Criminal Court, Banska Bystrica, dated 22/4/2022, file number BB-40/12/2020, the defendant, Mr. Piyu, was found guilty for the continuing, particularly serious crime of the illicit production of narcotic drugs and psychotropic substances, poisons or precursors, their possession and trafficking with them, whereby the court imposed a sentence of 22 years imprisonment. For the
Order!
For the execution of the imprisonment sentence, the court placed the defendant, Mr. Piyu, in a maximum security facility. Further, the court imposed on him the penalty of forfeiture of property, and the state is becoming the owner of the forfeited property. Thank you.
Speaker, sir. Mr. Speaker, sir, the communique issued by the Prime Minister's office on the 30th of April 2022 and today's reply in Parliament is in itself a contempt of the decision of the judge of the Supreme Court to refer this matter to the DPP for prosecution. So may I know from the Honourable Prime Minister, being given he has stated this Mr. UC is PU is such a big criminal, how is it that when he was Minister of Finance and EDB was under his responsibility, this person was given an occupation permit for 3 years? How is it that even in 2020, when the Attorney General's office was informed how dangerous this person was, he was still allowed to stay in Mauritius? Even in October 2021, when the borders were reopened, he was still allowed to come in Mauritius and trade. How is it that today, after 3 years, you have the NUM to come and say that it is only now that you have woken up and decided that you use your powers under the Immigration Act to deport him? Have you inquired in 3 years what he has been doing in Mauritius?
You made your point. Let the Prime Minister reply. Order!
Mr. Speaker,
Order!
Mr. Speaker, sir, as soon as we were made aware of information of that nature from the Slovakian authorities, the authorities in Mauritius, the Attorney General, started to act immediately. I have given extensively, chronologically, the different process that the government, the different institutions, the different departments have engaged into in order to try to hand over this Slovakian national to the Slovakian authorities. I don't need to repeat again if the honourable member has not been paying attention and listening carefully to what I've been saying.
Mr. Speaker, listening to Prime Minister stands clear that government has failed to live up to expectation of law and justice, and that has been harbouring a criminal, since more than 4 years. In the light of the international warrant that was forwarded to the Attorney General's office and the request for extradition sent by Slovakian authorities to Ministry of Foreign Affairs, International Trade, can I ask him, following those two, one, the warrant and the request for extradition, when was the case referred to the police, knowing that this country has been harbouring a criminal since 2018? When was the case referred to the police, and whether he was called for questioning by the police since then?
Well, the honourable member, I think the honourable member, in fact, yes, he has not understood anything. He has not understood.
Wait for the reply.
Give the answer. Tell us when.
Wait. Okay. If you want to put questions for a few supplementary questions, I can allow, but I am reminding the House that we have already exceeded the time. Time is over already. Don't make an abuse of Parliament time.
Where have I mentioned in my reply that the case has been referred to the police for investigation? Where? I have tried to answer as slowly as possible so that members can grasp whatever I am saying. Then where has it been mentioned that a matter has been referred to the police for inquiry? I have said that when we received the information from the Slovakian authorities, they have requested for extradition procedure to be started. And I have then stated what has happened after that. So the honourable member is completely lost. Well, that I am, sir.
Wait. Honourable Boulel, don't interrupt.
Yes, as I'm saying, even in the press that he has been reading, nowhere is it mentioned that the matter has been referred to the police for any criminal investigation.
Okay. You made your point. You already had your question. Please, don't give replies to the question. Honourable Lachman Roy.
Thank you. Thank you very much, Mr. Speaker, sir. As a woman and as a mother of 2 children, I can only congratulate the Prime Minister for handing over the Slovakian authorities
Order here also.
Criminal involved in drug trafficking. I wish to ask the Honourable Prime Minister whether he can specify the nature of the offence for which Mr. PU was wanted in Slovakia, and whether he can therefore be concluded that the lawyer who defended him has been paid with drug-tainted money. Thank you.
Well, Mr. Speaker, sir, as I said, Mr. PU was wanted in Slovakia for establishing, masterminding, and supporting a criminal group, and also for the illicit manufacture, possession, and trafficking in narcotics and psychotropic substances, poisons, or precursors. I have also informed the House about the outcome of this case. He was found guilty with all those charges, and he was sentenced to 22 years of imprisonment. Now, with regard to how and what amount has been paid to some people, I will not be able to venture on this issue. I trust that the authorities will, of course, closely follow up on the issue, especially on the issue of potential money laundering or payment of fees which have been derived from criminal offenses that are related to drugs. I leave it to the authorities to just closely monitor and to see to it whether there has been any offense that has been caused. And let me say also one thing, because the Honourable Member, I've been listening, interrupting all the time. If you look at the affidavit that has been sworn by Mr. P.U., you will see how he has lied in his affidavit, saying that he is not a fugitive. He is not a fugitive in his country. When in the bail application, go and read the bail application, you will see that the magistrate himself or herself states that he is being looked for in the country. So I don't want, Mr. Speaker, sir, I don't want to take the time of the House to refer to those documents, but of course we will have plenty of time also outside to be able to speak about this case. And Mr. Speaker, sir, I think le peuple est en train de voir. Nous sommes en train de mener un combat. Nous sommes en train de...
Order on both sides of the House. Order on both sides of the House. Order. The table is advised. No, I am. Please. I have exceeded by almost 25 minutes. Bear with me. I'll give you 1 minute.
In 1 minute, le peuple est en train de voir que nous menons un combat contre le trafic de drogue, contre les trafiquants. Et voilà, nous voyons ceux qui sont en train de défendre ces trafiquants. Nous sommes du côté de la France. Et eux, ils sont en train de produire et de défendre les trafiquants.
Order here. Order. Honorable Gabin, I'm pointing at you. Order. Chief Whip, I'm pointing at you. Order. Order or you walk out. The table has been advised that PQ B614 has been withdrawn, B533, B529, B534, B535. All these PQs have been withdrawn. Question to ministers. MP Boda.
Thank you, Mr. Speaker. PQB 542.
Mr. Speaker, sir, as the House is aware, Government has, on the 6th of May 2022, agreed to the revision of bus fares. The bus fares have accordingly been increased by 5 rupees to 10 rupees, depending on the number of stages travel, that is, the distance between the origin destination points. Mr. Speaker, sir, arrangements have already been made to prescribe the new fares, which are effective as from the 8th of May 2022.
Mr. Speaker, sir, may I ask the Honourable Prime Minister, Honourable Minister, supplementary with the Prime Minister, but I didn't have the time. Mr.
Please behave yourselves on this side.
Mr. Speaker, this being a very harsh decision, may I ask the Honourable Minister why an urgent decision to reduce taxes on diesel could have provided a solution not to raise the bus fares in Mauritius?
Speaker, sir, the decision to reduce taxes on diesel does not depend on the Ministry of Land and Transport. I will ask the honourable member to send a parliamentary question to the minister responsible for the structure and for the price of gas oil and mogas.
The decision is a decision of government involving the Minister of Finance, because the bus fares relate to two issues. One is the budget for the free travel, and second, the budget for the BCRA, that is the recovery for bus companies. My question is, why it's a government decision. So he cannot, the Honourable Minister cannot ask me to refer to another minister. It's a government decision. My question is again, why, when he presented the case in Cabinet, why government did not take the decision to reduce taxes on diesel, saving so much trouble to so many people, because 500,000 people
you already made your point.
Every day
You already made your point.
Speaker, sir, I am sure that the honourable member is aware he has been a previous Minister of Transport, now being a member of this House, and he has been there for years. The transport industry, Mr. Speaker, sir, is heavily subsidized by government, as it is the case in most countries of the world. And this level of subsidy, which is provided to the industry, Mr. Speaker, sir, the honourable member knows, is correlated to the cost of the operations of the bus industry. That is, the major components of the subsidy relate to the cost of diesel and wages and other benefits. And this subsidy, the honourable minister knows, or the honourable member knows also, is channeled through this bus company recovery account, the BCRA, which was set up, in fact, in 2004. And this fund is funded through a levy per litre of ₹1.60 per litre from the price structure of mogas and gas oil. And the revenue obtained in the fund varies, of course, with the volume of mogas and gas oil which has been sold and consumed. And the expenses which are to be deducted from the fund and given to the different bus operators vary with a differential in the price of diesel and wages and other related benefits. Mr. Speaker, sir, the honourable member and other members of the opposition have complained about this increase. But may I remind him and all of his colleagues and friends, Mr. Speaker, sir, that in fact, at the time he himself was Minister for Land and Transport from 2014 to 2019, the revenue contributed to the BCRA was much higher. In fact, 880 million rupees were being injected into that fund. And the BCRA, which was initially set up to compensate for the bus operators for increase in price, was finally also utilized to compensate operators for the increase in the wages and other related benefits of the workers. Now, Mr. Speaker, sir, the honourable member and the House should know that the last time fares were increased were in 2013. And in fact, during that time, during the period of 2008 to 2013, fares were increased in 2008 and then in 2010 and then 2013. But from 2008 to 2013, the quantum of the increase during those 5 years was from 4 rupees to 9 rupees. And today we have increased from 5 rupees to 10 rupees. But the percentage was 31% at that time, just as this time, Mr. Speaker, sir. So from 2008 to 2013, for a period of 5 years, the increase which intervened after 5 years was 31%, just as today the average increase is 31%, although the stretch of time is 9 years this time, because last time it was 2013, the last increase, and today, 9 years after, we have increased the tariff fares by 31%, just as it was done for the period of 5 years, from 2008 to 2013. And the more so, Mr. Speaker, sir, to answer the honourable member. At that time, the price of the litre of diesel was 37 rupees 95, and it had increased to 2013 after 5 years to 43 rupees 95. So what I'm trying to prove, Mr. Speaker, sir, is that the price of diesel was lower even during those 5 years when we compared what has obtained today. In fact, from 2008 to 2013, the increase has been was 6 rupees per litre, whereas during these past 2 years, the increase has been from 2019 to now 14 rupees 60 depuis 2019. Pendant les deux dernières années, le fuel price has increased à 14 rupees 60 when we compare to what happened during those 5 years, 2008 à 2013, seulement 6 rupees, Mr. Speaker. So the average is the same, 31%. So the honourable member, I think, should look at the figures of the past before, or any other member for that matter, before coming to challenge. There was no choice after 9 years, Mr. Speaker, and the honourable member knows that the Singapore Corporate Enterprise, when he was minister, produced a report saying, Mr. Speaker, sir, that tariff fares should be reviewed regularly so that we should not invite such an unaffordable increase after so many years. But we have managed to increase the price by only 31%, same as under the Labour government from 2008 to 2013, although the price of diesel was much, much, much lower at this time.
Daniel?
Thank you, Mr. Speaker, sir. Can the Honourable Minister indicate to the House the number of commuters per day and the amount for disburse of paying bus fares out of their own pocket?
In fact, this is a question, Mr. Speaker, sir, which I think the answer should be made known to the public. We have every day, Mr. Speaker, sir, 465,000 Mauriciens qui voyagent dans nos autobus. Now, we have 105, according to our record, 105,000 who are senior citizens who do not pay tariff fares. We have 70,000 étudiants also in the same category. En plus, 40,000 fonctionnaires voyagent and they are refunded by government. In addition, 207,000 employees of the private sector travel and their tariff fares are refunded. En tout, donc pour répondre à la question de l'honorable membre, il y a plus de 400 000 personnes qui voyagent et dont les tariff fares ne sont pas payés de leur own pockets. Pour répondre à la question, c'est soit le patronat, soit l'État qui rembourse les tariff fares des fonctionnaires, ou dans la catégorie de nos senior citizens et des étudiants, évidemment, ils ne paient rien pour voyager dans nos bus.
The table has been advised that PQ B545-561 will be replied by the Honourable Deputy Prime Minister. Also, that PQ B537-598-607-611-574 have been withdrawn. Also, PQ B569, 586, 581, 597, 604, 566, 573, 613, 594 have been withdrawn. Next question.
B543.
Mr. Speaker, sir, as the House is aware, all matters pertaining to traffic signs falls under the purview of the Ministry of Land Transport and Light Rail and the Traffic Management and Road Safety Unit. The RDA, on its part, has the responsibility to implement road signage, road markings, traffic lights, and other traffic schemes on classified road and motorways after obtaining the required approval from the TMRSU. Mr. Speaker, sir, I'm informed by the RDA that there is no lack of direction signage on motorways and classified roads, and there is no such case reported to it so far. In fact, there are presently more than 10,000 road traffic signs under the responsibility of the RDA on these roads. These traffic signs are subject to normal wear and tear owing to environmental conditions and are thus maintained and or replaced as part of the regular maintenance plan of the RDA. As I mentioned in my reply to PQ B1156 on the 23rd November last, in September 2020, the RDA had procured some 2,700 traffic signs of the latest international standards, that is, using reflective diamond grade sheet for an amount of 4.1 million rupees and are being installed whenever and wherever required by the direct labor of the RDA. However, Mr. Speaker, sir, I'm informed that the TMRSU, as the authority responsible for traffic signage, is presently carrying out a road safety inspection on all classified roads, including motorways, to identify any hazard, faults, and deficiencies in the road signage system, including directional signs that may lead to accidents. Based on the outcome thereof, appropriate actions will be implemented by the TMSU and the RDA, including installation of additional directional signages if need be. Mr. Speaker, sir, as I highlighted in my reply to PQ B1156, I reiterate that for any new traffic signage or replacement of existing traffic signage, the RDA will use conspicuous signage of latest standard as advised by the TMRSU. Thank you.
Thank you, Speaker. Can the Minister ensure that for signage in dark spots, he will ensure that sufficient lighting is provided?
Mr. Speaker, sir, in fact, as I mentioned earlier, the strategy of the RDA is to provide diamond-grade traffic signs which have highest retroreflectivity and does not necessarily need additional light to make them visible. Nonetheless, the RDA has embarked on a pilot project to provide solar light at two locations, namely Petit Camp Branch Road in Quatre-Bornes and in Budge-Tombeau. The RDA is enlisting the collaboration of ESD, Energy Services Division of my ministry, and the University of Mauritius to work out on a specification for solar street lighting. Subject to the successful implementation of these two pilot projects and availability of funds, solar street lighting will be extended to different parts of the island.
Following recent incidents in certain public areas, can the Minister inform the House of the number of road signage that has been damaged and the cost thereof?
Unfortunately, Mr. Speaker, sir, we have had quite some damages following the recent occurrences of 22nd April 2022. Damages have been noted to various road signage at Cité Mangalcan, Budge-Tombeau, Mer Rouge roundabout on the motorway, Grande Rivière Nord-Ouest, and Cité Baléji. The damages amount to 300,000 rupees that will have now to be paid from public funds. As at to date, all damaged traffic signs have been removed and 40% has been replaced. Complete replacement is scheduled by end of May 2022.
Thank you. Can I ask the Honourable Minister, in regards to the survey that is being done by the Traffic Management and Road Safety Unit that he mentioned in his reply, when are they expected to complete this survey? Thank you.
As I've already replied, Mr. Speaker, sir, this is an ongoing survey. It's an ongoing survey that keeps happening, and as and when required, we keep changing. So, because these signage are subject to normal wear and tear, so we cannot like stop it at one date and restart again. So it's a permanent thing that keep on going across the island.
Thank you, Mr. Speaker, sir. Can the Honourable Minister inform the House if the Road Development Authority is considering of using cat size on the roads?
As I've mentioned already, Mr. Speaker, sir.
Order.
Yes, we are.
Order.
I guess it might be quite frustrated to keep putting questions and not replying them. Your turn might come someday. So, Mr. Speaker, sir, yes, in fact, the TMRSU and the RDA are working in close collaboration to bring in new technologies in the cat eyes, because now they also have, I understand, cat eyes that operate with solar energy and that get brighter at night. So yes, we are considering of definitely making our road much safer by, for instance, giving conspicuous, that is, signs that are easily visible in terms of size, in terms of borders, in terms of illumination, in terms of it being clearly visible, in terms of it being comprehensive, and obviously, and in all that road furniture that we add to make our roads safer, those cat eyes are in fact a very important component.
Remember, the table has been advised that PQ B567 has been withdrawn. At this stage, I'll suspend the sitting for 1.5 hours.